8 o'clock tomorrow, okay?
8 o'clock tomorrow for what?
Pre-trial conference.
Pre-trial conference starts at 8:30. I'm on the docket for 8:30. I will be there at 8:30.
No, I'd like you to be there at 8 o'clock.
8 o'clock for what?
We've already talked about that.
8 o'clock for you to talk to the state?
No, for me to talk to you. So you know
We're
what's going to happen.
talking now.
So, no, but there's going to be...
What new evidence, what new information would you have from now to 8 o'clock in the morning?
I'm going to have a discussion with the prosecutor before you come in the courtroom.
About what?
About your case. And you want
about me taking a plea deal that I told you I'm not going to take?
You would like an answer to your question. You asked a question, so let me answer it. I'm going to be speaking to the prosecutor between now and when you come to court in the morning. If I have a discussion with the prosecutor this afternoon, I will call you.
Okay, I got one last question.
I'm not finished.
Go ahead.
However, it's more than likely that I'm going to have a conversation with the prosecutor tomorrow morning. And I would like to talk to you before you get in front of the judge at 8:30.
Mm-hmm.
I'll be the first attorney there in the morning. You'll be one of the first cases called. Okay? So I'd like you to be there at 8 o'clock.
Okay. One last question, since you're not going to pull up any evidence, okay, post November 7th, not even a day later, restraining order evidence.
It has to do with relevancy.
Court evidence.
It has to do with relevancy.
She wrote down in black and white what she says happened that day, and she gave testimony, sworn tape testimony, as to her version of what happened that day.
Okay.
That's why it's relevant.
Okay.
Okay. My next thing is, my last question is, what statute states that the judge can put her in jail for 180 days if she refuses to come in for deposition?
The civil contempt statutes.
Could you write that down so I can take it home and research
look it up.
Mm-hmm. Can you write it down so I can take it home and research it?
I will look it up today. If I don't look it up today...
So you don't know either?
Ma'am, I'm very familiar with the statutes, what they say. I haven't memorized every number, okay? It will
so
take
why
me,
would she be in contempt of court?
It'll take me a few minutes to look it up. I have your email address. I will email you if I can do that today. But I'm 100% sure that the civil contempt statute says the maximum penalty for being in indirect criminal contempt of court is 6 months, 180 days.
Civil. You just said civil. Why would you say civil? This is a criminal case.
Because it's considered civil contempt when you violate the court's orders.
So I need to look up civil. Civil contempt.
Yeah, civil contempt. Indirect civil contempt.
Could you write, why can't you write it down?
There's two types of contempt. Because I'm going to remember this, because I'm going to go to my computer in a few minutes and I'm going to look this up.
But you're going to use keywords, civil contempt.
Yes.
Indirect civil contempt.
Yes.
And he can put her in jail for 180 days for that.
Yes. Or he can hold her indefinitely until she testifies in your trial. So if your trial doesn't happen for a year, she could be held until she testifies.
So let's say, I'm just going to use a scenario. Let's say she goes out of the country again like she did before in 2012, goes to Jamaica. That's her right. She has a passport.
Well, first what has to happen is she has to be served with legal service. Okay? In order for her to have a legal reason to appear in court, she has to be served. I think there's a problem right now in getting her served. Secondly, what has to happen is there has to be a hearing called a rule to show cause hearing to give her the opportunity to explain why she didn't follow through with the legal service. Then what has to happen is the court has to make a determination of whether or not she violated the court's order. If the judge determines that her violation of the court's order was not willful, then start the process over again. If the judge, however, finds that she willfully violated the court's order, then he can proceed to sentencing her or providing a remedy for fixing the situation.
So, let's say she goes to Jamaica and she stays there 6 months on vacation, or just goes there. Let's say she just wants to go back to her home country. Then what? What do you do?
The state attorney can move to extradite her.
He can?
Yes.
So even though she hasn't been charged with a crime, he could extradite her?
Yes. She's a material witness in a felony case in the state of Florida.
Mm-hmm.
Now she goes
material witness in the defense or in the prosecution?
In the prosecution.
Mm-hmm.
Now she goes to a country where we don't have a treaty. It's going to be pretty hard to extradite, but most countries we have treaties with,
mm-hmm.
and you know, kind of reverse
so
the situation.
So let's say she serves 180 days, and then what?
As soon as she's in jail, they can move her very easily to the podium to testify in front of a jury.
So you're saying they can
I doubt she's going to have
her?
very nice things to say to you.
Are you saying that they can coerce her to say something?
They can coerce her appearance.
Okay. So what are you going to do before it goes to court? Are you going to bring her in to cross-examine her?
Her unwillingness.
Or are you going to allow her to just come before the court and say whatever she wants without you having taken out time to cross-examine her first?
Her unwillingness to attempt to prosecute you actually adds to her credibility.
And then if she doesn't come forward, what other witnesses do you have?
Think about what I just said, please.
If she doesn't come forward, what other witnesses do you have?
I'm not prosecuting you, ma'am.
Okay, so isn't this evidence you would have received from the state attorney by
I am not prosecuting
now?
you.
So she's your only witness? She's their only witness, right?
No, she's an important witness for the state. There are other witnesses, include Mr. Valentine Sr. and the kids and the police officers.
And what did Mr. Valentine Sr. say again?
He witnessed the aftermath of the incident.
According to who? You?
According to him.
When did he tell you that?
It's in the discovery.
That's in the police report that I told you was a lie. This right here tells you that the police report was changed.
Ma'am, I don't have any evidence to say that the police officers lied.
Even Dr. Kremper read the report, and it says that the officer showed up at 8:33 an hour later, over an hour later. But you refuse to look into that.
A time difference is not a material.
Yes, it is, because I could have been murdered within an hour. I could have been dead right now.
It's when the officer thinks about 3 or 4 days later and he writes his report, and he was like, it was at 8 o'clock or was it 7:50? You know, what time was it?
But he didn't correct the whole report, did he?
No, but I don't have any evidence to say that he made up what Mr. Valentine said.
I told you.
That's a big difference.
You guys,
do you understand? That's a big difference.
You'll change that too, because like you changed the 911 recording.
Yeah, I'm not prosecuting you.
I know
okay?
you. But I'm not saying you. I'm saying whoever.
You just said
changed
me.
the 911
You just said me.
The state changed it because they get the recording before Miss Montreal.
I don't have any evidence.
The state
You've had like 4 or 5
I
prosecutors. I don't know if you realize that, but I don't have any evidence that any of the prosecutors that have been on your case have been gunning against you in any way, shape, or form.
But you're not even going to go over that police report and challenge the state. You're not going to challenge the state on the 911 recording, the police report. You know, it does say that language in the law, challenge the state from my client's right to speedy trial. You're not going to do that. Because what you have allowed the state to do is as if the law never existed. You've allowed them to eviscerate that. You've allowed them.
8 o'clock tomorrow, okay? Ma'am, thanks for coming, okay?